We are going live now, ma'am, on our YouTube channel. So we will start the session now. A
Yes.
warm, happy evening to all the participants who are joined with us to gain the knowledge. I am Nirmal Kumar Jain, a law student and a founder of Law Gardener. On behalf of Law Gardener and team, I welcome Advocate Shelley Ezhil, ma'am, who have come here and gave their time from their busy schedule to share the knowledge on importance of protecting intellectual property rights. I would also like to welcome all the participants, which include law students, lawyers, and common man. Uh, Before starting the session, I would like to give brief introduction of our today's guest. Advocate Shelley Ezhil ma'am is associate partner at Altacit Global, a leading law firm. She currently heads the Bangalore branch of Altacit Global. Ma'am is an experienced IP attorney and consultant. Ma'am specializes in intellectual property rights advisory, prosecution and management and corporate laws. Ma'am is a regular speaker at various forums and is credited with publication in national journals. She has been also been active in writing articles in varied fields of law. Ma'am holds a Bachelor of Law degree from Tamil Nadu Dr. Ambedkar Law University, Chennai. Now I request all the participants to do subscribe to our channel so you can get the notification for our future webinars and other videos. Now I request ma'am to take the session further.
Thank you, Nirmal. Thank you for the warm welcome. Good evening, everybody. Today's topic of the webinar is importance of protecting intellectual property rights. So, as we all know, intellectual property, some of us do not know why we need to have this intellectual property protected and what importance does this protection have. So, intellectual property, it's an intangible aspect dealing with creations of human mind originating from ideas and expressions. So, the word intellectual denotes the works produced as a result of creativity. When we say intangible aspect, it means it cannot be seen or felt or easily ascertainable like any of the physical or a tangible property that we can easily see or the value of it easily ascertained. So, since these creations are intangible, that is, that cannot be seen, it becomes necessary to protect the inventors and the creators and the inventions and the creations that they have created, and also to appreciate their efforts and recognize their efforts. Hence, a set of rights are provided to protect the moral and legal interests of such inventors or the creators. And this forms the discipline of intellectual property rights. So, intellectual property rights, what are those? So, IP rights are bundle of exclusive rights granted to the lawful owner. So, what do these exclusive rights do? They safeguard the inventor and creator and also bring them the recognition that they deserve. And it protects the invention and creation for a limited time as provided under the different IP laws. And it provides exclusive right to control the use, manufacture, sale of their IPs that they have created or invented. And also, this rights ensures that these inventors and the creators monetize their invention and benefit out of it. So, intellectual property covers a vast range of activities and it plays an important role in both cultural and economic life. So, it is important to be aware of what these IP rights are and how they can be protected, and in due course, how to benefit from them. So, with this introduction, let us get into detail as to why intellectual properties need to be protected and what does this protection of IP rights mean. So, if we all know, necessity is the mother of invention. So, imagine if humans have not invented fire or any of the inventions that have made the lives easy for us. And would human lives have progressed without entertainment or the ways to express it? So, Let's even see, in if the person who has invented fire has not shared his invention with anybody, what would happen to us? What would have happened to us? So, constantly, the humankind has progressed with new ideas and creations. So, from fire to the most recent technological inventions like artificial intelligence and the digital arts, creating music, uh, coming up with brand names or products or processes require considerable resources, uh, and these resources also require investments financially. Since the creations and inventions of the owner are being utilized and enjoyed by others like us, it is only fair to let the owner have exclusive right over the use of their creation or the invention and monetize it. So, in a way, it becomes important to encourage, appreciate, and incentivize the creators commercially so that the effort, time, and investment made by them is rewarded with recognition, and they have financial benefit, and also it encourages them to create more. Say if we don't encourage any inventor or the creator and we shun their work or use it without their knowledge, and thereby creating a loss for them, how would they be motivated to innovate more or create more? And you know end of the day, we shouldn't be just the copycats, but also let the innovators and creators create more and thrive. So that is why it becomes essential, and in giving them the exclusive rights to use and monetize to the exclusion of third parties, and also set terms as to how and when their intellectual property should be used. So when we say exclusion of third parties, it means that only the innovator and the creator have the right to use it, and no third party can do it without the permission of the owner. So it in a way it is a negative right. Intellectual property is the only negative right that stops others from using it, but gives the right only to the owner. So, we shall now see in detail why protection and registration of various intellectual property is important. So, let us compare it with a physical property. So, as we have already discussed, intellectual property is an intangible property. So, let us compare it with a physical property that we can see. When we buy a property, we make sure that the documents are in place or in order, and the title duly transferred, and the sale deeds or other documents registered. Why do we do that? We don't simply just go buy it and say that we are the owner, and uh, just own that property. How do you establish ownership? Only by getting the documents registered. Only by registering, you are establishing ownership to that property. Similarly, for intellectual property rights, intellectual property which are intangible, you can have these registrations to establish ownership to the IPs that you have created, and also it helps you to enforce your IP rights later. So, registering intellectual property under relevant laws establishes the ownership, like we mentioned, to such intellectual properties that you have created. Thereby, you protect the right of the owner of such IPs. So, not only does it protect, it also ensures that the owner gets to exploit it commercially during the validity of the IPs. So, when we say commercially exploited, so in cases of physical property, when you own a property, you can lease it, you can rent your property to others. Similarly, you can also do that with the intellectual property by granting license to use or manufacture, or you can even assign the rights. So another important thing to remember is that intellectual property rights are territorial in nature, meaning where you seek registration, the protection is given only in that particular territory and not worldwide. So that is why it is prudent to obtain registrations and protect one's intellectual property in the relevant territories that you wish to seek protection. So there are different laws relating to different types of intellectual property. And when we say different, it is also different in different countries and regions. So let's move on to the types of intellectual property. Intellectual property is an umbrella term used mainly for two categories, that is, industrial property and copyright. So, the term industrial property includes patents, trademarks, industrial designs, geographical indications, etc. So, what are patents? Patents are exclusive rights granted for the public disclosure of an invented process or product and to protect that technical inventions. So, this right provides a person or the inventor or the legal entity with exclusive rights to manufacture, use, or sell their invention and exclude others from doing the same. And if anyone infringes or use it unauthorizedly, then the owner can also stop and claim for damages from them. But this right to monopoly is limited only for 20 years. And after the expiration of the term of protection, the subject invention enters the public domain for any third party to use it commercially or otherwise. So, Patent Act 1970 deals with protection and registration of patents in India. So the three main criteria for qualifying criteria for patent is the invention relating to a product or process is new or it should be novel, meaning that it should not be known to public, and it should have inventiveness. That is, there should be some technical advancement or an inventive step that is not obvious to the person who is skilled in that particular field. And the other criteria is that the patent should have some industrial applicability. So there are other criteria that explain what cannot be patented. For example, a mere discovery of a substance that is already known, or any frivolous inventions that is against the public policy, and so on. So, as mentioned earlier, patents are territorial in nature. So, meaning if protection is sought in India, it is that protection is provided only in India. And it is also important to note that there is no worldwide protection offered for patents. If you wish to protect your invention in other countries, then you have to file application in that particular country where you want protection from. So for international filings, there are two international agreements that pave way for easy filings and offer right of priority in patents. So one is the Paris Convention and the other one is PCT, that is the International Application through Patent Cooperation Treaty. So protection of patent thus ensures that the owner gets to enjoy commercial exploitation for a limited period, that is 20 years, including making, using, selling, licensing, or and any unauthorized use or selling of the same would amount to infringement, and the patentee or the owner of that particular invention can stop unauthorized use or sale and claim damages for loss of monetary benefits, that is rightfully the owners. So moving on, the next type of intellectual property is the industrial design. In what is industrial design? It is commonly given for ornaments or aesthetic aspect of a product or commodity, and it constitutes shapes, patterns, 2D or 3D ornaments. So the common question that gets asked often is, what is the difference between a patent and a design? To answer it simply, you know, if the look or the aesthetic part needs to be protected, then you can file it under industrial design. But if you want to protect the functionality of that product or the process, then you can file it under patents. So industrial design is only for the aesthetic look of a product. Protection can be granted to designs which are usually novel, that is, it should be new and it should be original. And another criteria is that it should not be present in public domain, because this ensures that the protection is afforded even before the product is commercially launched in the market. Thereby, it stops any illegitimate products from destroying the original design and the efficacy of the original product. So, uh, the industrial design protection can be granted to designs that have industrial applicability, or to be simply put, it must be capable of being produced industrially. So, like patents, these are also territorial in nature. So, if an Indian applicant wishes to file in other countries, he can do so using the Paris Convention in their member countries. And the validity of design registration is for 10 years and can be extended for a further period of 5 years, post which it goes into public domain. Moving on, the other important intellectual property is trademark. So, trademark is a word, phrase, symbol, or design, or combination of it that distinguishes your product from somebody else's. So, basically, you are able to identify a particular good or service just by or associating that goods or service to that of the brand name belonging to a particular company. So, when a business becomes successful, it paves way for copycats selling products illegally and thereby profiting from the reputation a brand has created. And it may, in the process, damage the reputation earned by the business in the brand. For this reason, the trademarks reflect reputation of a business and becomes most valuable asset of a business, because it is used as a marketing tool, as a way of labeling, and hence protecting trademark IP is crucial for a business. Registration of a trademarks, like other IPs, also establishes ownership, and here and it makes it easier to enforce their rights against any infringer or any third party using it without the authorization of the owner. So, for a trademark to be registered under the Trademarks Act in India, it must it must be non-generic. It must not be descriptive of the services or the goods that they are providing, and it must not be identical or similar to some marks that are already existing, and it should not be deceptive. So protection of trademark registration is valid. It's the validity is for 10 years, and it can be perpetually renewed for further period of 10 years. So legal protection, what does it do? It enables the owner to control who uses their trademarks and how they are using it, and it also in turn the assures the consumers of the genuinity of the products that they are purchasing. Because if I buy any counterfeit product, thinking that that comes from the reputed brand, and I'm disappointed, and in turn it is a fake product, then wouldn't it affect the reputation of the original brand owner? So that is why protecting trademarks is very, very important. And trademark registration also helps promote their goods and services without being undermined by counterfeiters. So, just like patents, there is no worldwide registration for trademarks, but international registrations can be obtained by filing individually in the countries that one wishes to seek protection, or through regional conventions or via Madrid Protocol. So the other IP is geographical indications. So they are similar to trademarks, but they serve as an indicator that identify goods originating from a specific geographical location which possess certain qualities or a distinct quality, reputation, and characteristics of the goods to the place of the origin. For example, Mysore silk, Chennapatna toys, or Tirupati laddu, champagne, etc. So, any organization or an association of people or statutory authority can apply for registration of geographical indications, and the validity of GI is for 10 years and can be renewed for further periods of 10 years. So, this protection, just like trademarks, not only protect the owners but also informs the consumers that the products that they have purchased actually do come from that geographical location and possess the quality that particular place claims. So I cannot buy a store bought laddu and sell it as Tirupati laddu, to be very simply put, to be very precise. So the next IP that we are going to see is the copyright. So copyright is a legal right providing exclusive authority over the creator's work, including distribution and use of the work. Copyright is granted to protect literary, artistic, musical, and dramatic works, cinematographic works, sound recordings, etc. And it also protects the interests of those who are associated with such copyrighted works, like performing artists in their performances, producers of phonograms in their recordings, and those of broadcasters in their radio and television programs. Copyright also covers softwares, databases as well. And one thing that is very, very important to note is copyrights do not protect ideas but the expressions of it. So that's why we see a lot of similar storyline, but the expression of how that story is created or rather produced into a movie that gets copyright protection. So protection of copyright, what does it ensure is it ensures the economic right to use, distribute, license, translate, reproduce, perform, or broadcast, and also enables the owners to receive royalties. So, apart from the economic rights, what copyrights ensure or rather provide is the moral right, which ensures that the work of the author or the work that is created is attributed to the original author and prevent it from being altered or tampered with or damage the creator's reputation in any way. So the term of protection for a copyright is for artistic, literary, musical, dramatic work, it is the lifetime of the author plus 60 years. And for sound recordings, cinematography, and photographs, it is 60 years. So copyright, the minute it is created on a tangible medium, it is automatically created. So registration of copyrights is not mandatory, but registration establishes ownership, and if anyone wants to enforce their rights against any unlawful or unauthorized use of the original work, then the registration will come handy because it establishes who the owner of that particular work is. So, unlike other IPs, copyright protection in India is extended to its member countries under Berne Convention. And so we don't have to file separate applications in different territories. So, apart from these intellectual properties, are the protection of new plant variety, which provides exclusive rights to breeders over propagating materials of a new variety of a plant. And the other one is the semiconductor integrated circuit layout design, which provides protection to the design layout of circuits. So, with this, I would like to conclude by saying that The protection of intellectual properties are important as it not only enables the owner to commercially exploit his work, but also stop unauthorized use or unlawful use and claim damages for the loss and hardships, including monetary loss. Thank you. If you have any questions, I can take it up now.
Yes, ma'am. We will start with the Q&A. And our first question is like, what is unrealistic and arbitrary trademark?
Unrealistic and arbitrary trademarks. See, when we say trademarks, it should be non-generic. When I say non-generic, it should not have a generic word like you are like a basket or sun, moon. Okay, so these are generic words that the IP rights are, like I've mentioned, a negative right. So if you claim uh, right over a particular trademark that is generic, it means that you are stopping others from using that word or the trademark anywhere else. So that is why certain limitations are put. So unrealistic and arbitrary trademark would also it or those marks which should not be generic, which should not describe the product that they are selling, and it should not be deceptive. Say I come up with tasty cupcakes, or rather bad cupcakes as the trade name for my cupcakes. What do I mean by that? Am I saying that the mark is bad, my cupcakes are bad or good? So these are some of the examples of unrealistic trademarks that cannot be protected. So while choosing a trademark, you have to be very careful. The invented trademarks do stand better chance of getting good protection, and also you'll be able to it would become a valuable aspect of your business. So choosing the right trademark makes a lot of difference in your business.
Yes, ma'am. So move to the next question. So can I protect my trademark by registering it before I actually start using it in my business?
Yes, you can. So in India, you can actually file for trademark registration of a mark that you have actually conceived or developed or created, but you haven't started using the mark. So you can file it as a proposed to be used mark, meaning that you are proposing to use the mark eventually.
Yes, ma'am. So, like, what is the procedure of like a trademark? Like, how when we file, how long it does it take, ma'am? And also,
Okay, so the simple procedure of trademark registration is before you uh, for file an application for trademark registration, it is usually advisable to conduct a search to ascertain whether any similar marks are already in the records of the register or not. And once you get a green signal, then you can file for an application of for registration. Normally, what people think is that while filing an application, it is automatically uh, granted registration, but no. So you are only filing an application for registration, and that application has certain processes till registration. So once you file the application, the registry examines your application and sees whether your trademark is registerable or not. And if they have any objection, they would send an examination report for which a reply has to be filed. And if they are satisfied with that, they may publish it in the trademarks journal. Otherwise, they may schedule a hearing. So once it is published in the trademark journal, it is open for any third party to oppose the trademark for 4 months from the date of publication. And if nobody opposes the trademark, then it proceeds for registration. So this process, say if the mark is an invented one and it does not receive any objection from the trademarks registry, Give or take, you will get the registration certificate in 6 to 8 months time, or 8 to 12 months time, the maximum.
So maximum we have to wait for a year to get a registered
Yes, but
certification.
nevertheless, nothing stops you from using the trademark. So
Yes, ma'am.
normally, one assumes that until you get the registration certificate, you're not supposed to use your trademark. But no, you can use it. You can also indicate the letters TM or SM, meaning trademark as SM, until you get the registration certificate. The minute you file the application and you get the allotted number, then you can start mentioning TM or SM. It goes to show that you have filed for registration and certain proprietary rights vest with you.
So, ma'am, is it illegal to use TM without registering or without getting a certificate, ma'am? Like without filing a registration?
It is, yes, I wouldn't say illegal, but it is a deceptive practice because by mentioning that, the reason that you mention is that people become aware that you have filed for the registration, so that registration process is pending. So when you indicate it without having applied for registration, that it is deceptive, so that you are not supposed to do.
Yes, ma'am. So we'll move to the next question, ma'am.
So
What can I do?
and
Yes.
also uh, you shouldn't use the word registered or the letter R without obtaining the registration certificate. Only after the mark gets registered can you mention it. Until then, you can mention it as TM.
So TM we can mention before registration also, like before applying also.
No, TM you can mention the minute you apply for an application, trademark application, while it is pending registration. Once you get the registration certificate, you can mention the word registered or the symbol R.
Yes, ma'am. So we move to the next question. So what can I do if somebody basically using my registered trademark?
If your registered trademark is being misused by somebody, you can always take action against them. One, by sending them cease and desist notices and asking them to stop using it immediately. And if they don't adhere to it and they continue to do it, you can take them to court
Yes,
and
ma'am.
claim damages for that.
Yes, ma'am. So, ma'am, what if two parties are using same trademark and they haven't registered? Then who has the more right, ma'am?
So the one who has the capacity or who has started it much earlier than the other person, and he has all the reasons to show that the public are able to identify the goods or the services that he is providing to that of his business and not the other person. So he must have all the necessary documents to show that he is the prior user, and also that the goods are being identified only with his brand and not the other competitor's brand or the other person who is using a similar mark.
If they're both in the same industry, then, ma'am?
Same. Even if they are in the same industry, supposing you and I are using similar, I wouldn't say similar mark, identical mark, and but you have been using it much earlier than I, then you can show that you are the earlier user or the prior user here, and also you have and the public are buying the goods and products thinking that it comes from you and not mine. So it's a battle, so you have to establish who is the original user who has has come up with this particular trademark, and how they have been using it.
Yes, ma'am. So, ma'am, my next question is, what is trademark class, ma'am? On which, on if what, like how to know on which, like my business fall into which class and how should I register that?
Okay, so Indian Trademark Office follows niche classification. So there are 45 classes under which you can file a trademark application. So classes 1 to 34 deal with the manufacturing sector, and from 35 to 45 it deals with services. So you'll have to see what based on the products or the services that you are providing, under which class your goods or services fall under, and accordingly you'll have to file applications in that particular class to secure protection in that particular class.
Yes, ma'am. So my next question is, ma'am, who can apply for a trademark? That is just individual or a business or a partnership or some
Yes,
other thing.
anybody, individual, company, partnership, startup, so anybody can file for a trademark application.
Yes, ma'am. So what is the source of trademark laws in India, ma'am?
Meaning, I didn't get your question.
Like origin of trademark, like is it from the Indian, like example? Yeah. What can I give for example? Like trademark laws means is originality. Like we have call, like for as a example the constitution. Were writing the constitution. We have taken example of different constitutions. So while trademark laws, like we have when we taken the source of like other countries or something, like we have made a new.
So we, how do I put it? So IP laws in general. There is a myth also which says that when Taj Mahal was built, Shah Jahan ordered the thumbs of those who have built it to be cut off. So probably that's one of the crudest forms of protecting IP. So it's universal, and that's how we relate, and we.
Yes, ma'am. So we move to the next question, ma'am. What is fair use, ma'am?
So fair use is usually recognized under copyright laws. So when s- when we say that copyright protects literary, artistic, and musical works, dramatic work, and without the author's um, confirmation or author's permission, one cannot use it. But if you, for some reason, like for academic purposes, or to refer it, to compare it with something else, or for research purposes, you want to use that, or use certain phrases, or use certain clippings of that work, then for that particular work you are applying, then it becomes fair use, even without you getting the permission from the owner of that work. But you'll have to establish what purpose you have utilized it and how it falls under fair use. So usually for academic purposes, research purposes, and for showing that this, so say for example movie reviews, somebody does it, they don't show the entire clipping, but they just talk about the movie and use the posters or the clips for, and this would fall under fair use.
Yes, ma'am. My next question is, ma'am, which laws does YouTube India follows, ma'am? As if we see in most of the videos, YouTuber put a disclaimer as content is protected under Section 107 of Copyright Act of US laws. But if we go for the Indian Copyright Act, it is Section 52. So law of the land should be followed according to me. But what YouTube India follows, ma'am, in general. Ma'am, shall I repeat, ma'am? Hello,
I'm not a.
hello,
Hello.
ma'am. Can you hear me, ma'am? Yeah. Please wait for a minute. I think there is a network issue. Ma'am will be rejoining us soon. I think there was network issue, ma'am.
Yes, I think so. I'm still not able to hear properly. Can you hear me?
Yes, ma'am, I can hear you. Ma'am, can you hear me, ma'am? No.
I'm not able to hear.
Ma'am, can you try to log out and
Yeah.
please wait for a couple of minutes. We are resolving the issue. Ma'am, is it I'm audible, ma'am?
Yes, I can hear now. Yeah.
Shall we resume it or is it proper
Shall
now?
we close it? So, anything else that we
We have
would
just
like to
some
discuss?
couple like 5 to 6 questions, ma'am. Not more than that. If
Okay, I think I've.
just one, it will take
Okay.
hardly 10 minutes, ma'am. We will deal with one. Yeah, we'll go with the participant question. Dhruva, can you please showcase the. Yeah, a question by Shiva. My published work has been reproduced without my permission. So what can he do?
Okay, so you can approach that. So we'll have to see where it has been reproduced, and you can approach that person, and you can tell them to either credit you or uh, take it down because it has been reproduced without your permission.
Yes, ma'am. I think he would have got this answer, and we will move to the next question. So, a question like my YouTube video has been posted in other website without my permission, and it's more than one website. So, how can I stop this misuse?
Uh, so you can without your permission in more than one website. So you can take down the details of the websites where they have published it, and if you are able to uh, get the details of the person who has published it and either file, you know, send them notices.
Yes, ma'am. So, next question is how can I manage copyright protected works, and what are the collective management organizations?
So that's a topic for another webinar, I guess. We can discuss in detail that one.
Yes, ma'am. So, if you like to give in some short answer to this question, ma'am.
See, always for copyrighted works, that I would say is that have the photo watermarks, and always state that this particular work belongs to so and so, copyrighted works of so and so, in each and every where that you are displaying your work. So that way you are establishing that that particular copyright belongs to you, the owner. So that is one way to manage the protected works of copyright.
Yes, ma'am. I I think, yeah. Yeah, we have finished with the questions from the participant side. My last question, ma'am, does NFTs can be protected under Copyright Act, ma'am? Non-fungible tokens.
Yeah. It can be. It can be. We'll have to see. We'll have to see the specificity of your question, and then if you ask me bluntly, yes, it can be.
Okay, okay, ma'am. So as okay, there were ma'am. If we can continue, or can we shall we close the session, ma'am?
So we can close it. I think
Okay,
there is.
fine, ma'am. So, as due to some issues and other technicalities, and we are just closing the session, and we have come before concluding the session. My last question to ma'am is: as what is your advice to the student and the youth to grow in this field, and any other advice you would like to give, ma'am?
Okay. So, when it comes to intellectual property, and you're all present all over on social media, so understand what you are creating, and also try to safeguard the things that you have created, and also ensure that you are not misusing or infringing on somebody else's right while you are present, or do posting your work or your creativity in any platform. So that would be the advice that I would like to give from IT perspective.
Thank you, ma'am. So now I would like to conclude the session by thanking Advocate Shelley, ma'am, for providing us the time from their busy schedule and giving us the wonderful insights. And I would also like to thank my team for making this webinar successful, and also like to thank all the participants for participating in the session, and pardon us for the technical disturbances caused. And also do take the vaccine and be safe from the COVID pandemic. Thank you, ma'am.
Thank you. Thank you for this wonderful opportunity, Nirmal. Thank you.
Thank you, ma'am. Please end the session, Dhruva. Live session.